Yes, ma'am. Good morning.
Good morning, Your Honors. May it please the Court. Leslie O'Brien for Ramel Ahart. Mr. Ahart was convicted of first-degree murder primarily on the testimony of a witness by the name of James Miller. Mr. Ahart says that he was denied his right of confrontation when his trial counsel was prevented from cross-examining Mr. Miller, the key witness, regarding whether he knew that his own testimony, his own story, could form the basis for a conviction for first-degree murder.
Well,
I'd state that
the question was really very specific about that you've committed joint. Well, the first one was, I mean, it named the crime. I mean, it had a lot of legal implications, is what I'm trying to say.
It did, and I would like to, I can state the exact question, and I would like to discuss that. The exact question was, do you know that the story you tell about driving with soon-to-be murderers in the car yourself, that you could be that could be considered as an accessory before the fact of murder? And I do want to address the exact nature of that question, but if the Court will allow it and bear with me, I'd like to just take a few sentences to say what it was in Mr. Miller's story that the defendant says formed the basis for, that clearly formed the basis for a conviction for first-degree murder. Mr. Miller's story was that he was driving around with the eventual murderers. They asked him to get a gun, that he tried to get a gun. He testified that they told him that they wanted to kill Corey Davis, that they wanted him, he testified that they wanted him to contact Corey Davis and find out where Corey Davis was. He testified that he did telephone Corey Davis, asked Corey Davis where he was, told Corey Davis to contact him, Miller, when Corey Davis reached Cambridge. Miller testified that Corey Davis, in fact, did call Miller, that there was a conversation about the fact that Corey Davis was now on Hamilton Street in Cambridge, and that at that point, according to Miller, the two killers that Miller identified left to go and kill Corey Davis, and Miller states that he then got on the phone, never warned Corey Davis, who he said was his friend, that these people were coming, then afterward fled into Boston with the killers, gave numerous versions of the facts, lied to the police, and asked his girlfriend to lie for him. I'd suggest that, I submit that that would survive a motion for a directed verdict every time against Mr. Miller for first-degree murder. So the question became whether he was aware of that, because if he was aware of it, he had powerful reason to curry favor with the prosecution, and the defendant had a right to question him about that. But when the defense counsel did attempt to question Mr. Miller about that, there was, of course, an objection by the prosecutor that was sustained. Defense counsel tried again. The objection was sustained a second time. So he never came back to it. And in fact, in the prosecutor's closing argument, he told the jurors that James Miller had nothing to gain by pointing the finger at Ramel Ahart and testifying that Ramel Ahart was the murderer.
But your claim is not. Your claim is that it was prosecutorial error and judicial error, or prosecutorial misconduct, or improper objection, and improper statement about it can't, and judicial error in not allowing the question, right?
Yes, those are the arguments that I've made, and I realize that it could be construed as possibly that defense counsel did not pursue this far enough. I've acknowledged that he did not object, and that the argument is that this gave rise to a substantial likelihood of a miscarriage of justice because the testimony of James Miller was so critical, because the prosecution strove with all its might to provide some type of corroboration for Mr. Miller when there was really precious little, if any, corroboration for Mr. Miller's testimony that it was Mr. Ahart rather than himself.
But you wouldn't disagree, would you, that as framed, put aside the prosecutor's comment about, first of all, it can't, but just as framed, these questions were really positing a legal premise and asking, in a way, for a legal conclusion. I mean, they were not properly phrased questions, I think. One could certainly reasonably accept that the judge would sustain objections to that form of the question.
Well, I think you could say, Your Honor, that there was some surplusage in the question, in that the defense counsel did make reference to driving around in the car.
No, that's not what I'm talking about. I'm talking about that you would be charged with accessory before the fact. I mean, it was implicating what are the elements of accessory before the fact to murder, and then the second time, joint venture. I mean, so I guess I'm just wondering if the questions hypothetically were objectionable for that reason, you think, should the judge have suggested how to phrase them? Or
Well, no, Your Honor.
or you just don't think they were objectionable?
I don't think the question was perfect, but I think it was absolutely clear what defense counsel was trying to accomplish. And we have a situation here where the prosecutor is saying, well, my objection, which was argumentative, that was inartful. But he's suggesting that the court should have required this surgical precision from defense counsel in asking this question of the key witness in the case. And when you think about it, to phrase the question perfectly was just about impossible. Clearly, the defense counsel couldn't be expected to stand up and say, well, do you know that your testimony that you were driving around and all of the things that I just said that implicated Miller? It would be impossible to ask a perfect question like that. The question defense counsel asked was clear enough about what he was getting at. He was asking if Mr. Miller, if James Miller knew the jeopardy that he was in as a result of the story that he himself had told. So yes, it's not a perfect question, but it was clear enough what he was getting at. Also, I'd suggest that there was no...
Excuse me, wasn't there a little bit more to Mr. Miller's testimony than what you just described? I thought that there was also a part of it was that he was hoping to catch up with the victim before the two defendants, the two co-defendants, to warn him. Is that part of it?
Well, it's somewhat similar to that, Your Honor. He did say that when he got back on the phone, after he said the killers left the vehicle, Miller said, I got back on the phone and I told Corey Davis to meet me at such and such a place.
And the idea was to move him from where he was in harm's way so that he could avoid being shot.
Yes, although the jury could certainly have inferred that that was never said, because what actually happened was Troy Davis, the second victim, testified that they were lounging, smoking pot on Hamilton Street when the shooters arrived. And in fact, Troy Davis testified that what they were there for, they were expecting none other than James Miller. They were expecting to buy more marijuana from James Miller. That was the testimony. It doesn't make, I realize that was the testimony of James Miller, that he was trying to move Corey Davis. The jury certainly didn't have to, the fact
well,
that...
just stay with that for a minute. If
Yes.
that were so,
Yes.
then he wouldn't be an accessory, would he?
If the jurors believed that he was trying to get, if the jurors did believe that he was trying to get Corey Davis to move, yes. But there was powerful evidence that wasn't happening, and I don't think it really cuts into my point that his testimony, nevertheless, could have formed the basis for a first-degree murder.
Well, what if the witness had been allowed to answer the question, and he answered the question no?
Well,
Where would you be?
In that regard, Your Honor, I rely on the court's decision in Commonwealth v. Moorer, where the court stated that it's not necessary that the defense establish that the defense knew what the answer to the question would be. The defendant nevertheless has a right to explore the issue of bias. He doesn't have to know what the answer would be. But I'd suggest that
But where do you go with it? The answer is no. The jury can't do anything with that answer, can they?
well,
Then what are you going to do? Is the lawyer going to get into an argument with the witness on the stand?
Well, if the answer is no and defense counsel can't develop it further, he has reached a dead end. But that doesn't mean if defense counsel, puts all of his skill into this, he can't develop it, he can't get an admission that Mr. Miller knew that he was at risk for a conviction for first-degree murder, then defense counsel would have been unsuccessful. But that doesn't mean he shouldn't have been allowed to pursue it. And there are indications in the record.
Well, did the judge say you couldn't pursue it, or did the judge sustain the objection to the particular question asked?
The judge sustained the objections to the particular questions that were asked. And again, I'm stating that it was reasonably clear what defense counsel was getting at. He wasn't asking for a legal opinion from the witness. That would have been perfectly clear that he wasn't asking the witness as a lawyer what his opinion was. He was asking the witness what he felt his exposure was, and his exposure was to a conviction for first-degree murder, to a life sentence. Defense counsel should have been allowed to pursue that line of questioning. It was critical to the defense. I know that the prosecution says there's something cumulative about this. It was not covered anywhere else in the testimony. There was some testimony that Mr. Miller had some what appeared to be at least relatively minor charges, uttering forgery, larceny. He served he had a parole violation, had to serve 2 months as a result of that. His probation had to be extended, possibly at the behest of the police officers. But it all appeared very minor by comparison to the possibility of a life sentence, which in fact he was facing, and which I believe, or which I believe the record shows, that if it had been pursued, the answer would have to have been yes, or an honest answer would have to have been yes. Mr. Miller knew that. 2 months before, or 3 months before the case was tried, he was called into court, and Judge Bornstein gave him, in effect, the Miranda warnings concerning his testimony, told him that he had the right to remain silent, told him that he had a right to a jury. Now, Mr. Miller was reasonably sophisticated about the criminal justice system, because, as we know, he had several convictions, albeit relatively minor ones. So I'd suggest that he must have known that he was exposed, and that if he refused to testify, if he did not testify in a way that the Commonwealth liked, that he was in the deepest trouble that one could be in. If I can, I'd like to turn to the question regarding the witness, Ms. Andrade, and the improper closing argument by the prosecutor. Ms. Andrade testified that she saw 2 men in hoods walking toward the scene of the crime, and this was right before the shooting. She saw them walking toward the scene of the crime, and a short time later she heard shots ring out. She said 3 times that she did not remember whether these men were making telephone calls, whether they were on their cell phones. And in fact, she said twice that it was possible that they were making calls. And this, to the prosecutor, this was...
Didn't she first say, no, they weren't, and then said, not that I remember, or something like that?
I don't think she ever...
She did say no, didn't she?
I don't believe she ever said no. I believe she said she did not remember them being on the phone. And she twice said that it was possible that they were.
And in the closing, the prosecutor says she told you she has no memory of those 2 people being on the phone.
She told you she has no memory. What he said was, she told you she has no memory of these 2 people being on the cell phones. They weren't on the phone. He asked the jurors to derive from Jamie Andrade's evidence that these two individuals were not on the phone. Next page, the trial prosecutor says, Jamie Andrade has no memory of these people being on the phone, and yet 30 seconds later, shots ring out. On page 26, she told you she has no memory of these two people being on the phone. He, meaning James Miller, was on the phone. He was not on Hamilton Street. The prosecutor is asking the jurors to derive from Ms. Andrade's testimony that the people she saw on the street were not on the phone, and that therefore they were not James Miller.
Why aren't those reasonable inferences from the evidence?
Because she never said that there was absolutely nothing, there was zero in her testimony that would indicate that the people that she saw were not on the phone. She said she did not remember whether they were on the phone. She said
I thought
twice.
she said she did not remember them being on the phone. But it's possible they were on the phone. Anything's possible, of course.
Yes, if it's possible that they were, she's saying that they were it's possible that they were on the phone. She's not saying that they weren't on the phone, and that's the.
Don't remember them being on the phone. I don't remember them making a cell phone call.
Yes. So how can the prosecutor possibly properly ask the jurors to derive from that these people were not on the phone? She's saying she doesn't remember. She's saying maybe they were.
Well, the way I read that is that as she thinks back, she doesn't. In her mind, they aren't on the phone. It's possible they were. It seems to me that what you're talking about is if she'd said, I don't remember whether or not they were on the phone.
I think the exact wording was she didn't remember if they were on the phone. I don't know how to distinguish that from I don't recall whether they were on the phone. It seems to me that means exactly the same thing. And if she's clarifying that it's possible they were on the phone, then her testimony cannot possibly be interpreted in the way that the prosecutor 3 times asked the jurors to interpret it. And I'm asking the court to consider why this was so important to the prosecution, and I'd suggest that it was because there really was no corroboration. There was no decent, solid corroboration for what Mr. Miller had to say. So the prosecutor was stretching and reaching, and in closing actually told the jurors, you can take what James Miller said to the bank because it's corroborated. Yet all the corroboration that the prosecutor listed, with the possible exception of this testimony, if the jurors accepted it as the prosecutor wanted them to, it was all equally consistent with James Miller being the shooter. So this was this is not a minor point that I'm making. It was a major point, and the prosecutor recognized it as a major point, and that's why it was so repeated 3 times in his closing argument. I'd suggest to you that this was the theme of the defendant's case. The purpose and the entire effort that the Commonwealth was making during its case was to try to corroborate James Miller, who was a horrible witness, who admitted that he told many different stories, who admitted that he lied and lied again, and that these errors denied Mr. Ahart a fair trial. And I'm asking the court to return the case to the Superior Court so he can have the fair trial that he was entitled to. Thank you, Your Honors.
Thank you.
Thank you, counsel.
If it please the court, Special Assistant District Attorney John Verner from Middlesex on behalf of the Commonwealth.
Were you the trial prosecutor?
I was, Your Honor. With regard to the closing argument, there is no substantial likelihood of a miscarriage of justice when during the closing argument, the argument focused on admitted evidence, properly admitted evidence, and the reasonable inferences that can be drawn therefrom. Jamie Andrade's specific statement, to put Ms. Andrade in context, she was not related to anyone in this case. She got off a bus in Central Square, was walking down Brookline Avenue to to go to a party a few blocks from Hamilton Street, the location of the murder.
Can I just back up for a second? You said there's no substantial likelihood of a miscarriage of justice?
That is correct.
Are you conceding that there was error in the closing argument?
Absolutely not.
All right, okay.
Absolutely not.
All right.
So Miss Andrade sees two black males with hooded sweatshirts, dressed in the same manner as James Miller stated they were dressed. She said one of the males was 4 inches taller than the other male.
And I take it this is very close, within a car's length she sees them?
Yes.
Okay.
She's talking about how there are cars. She's so concerned about her safety, being a young woman walking at that hour of night by herself, that she makes these observations.
May I ask, I have a recollection of some description of the two fellows wearing gloves.
That is correct.
Did her description of these two men include any talk about gloves?
They did not, Your Honor. The testimony at trial from other witnesses from James Miller was that the gloves were purple surgical gloves. The testimony is that they were baggy, hooded sweatshirts. Miss Andrade did say at trial that she saw the hands, but she also said she saw their face and their noses, and she deduced that they were young black males.
But in fact, she saw their hands, and the fact that their hands were black was part of the reason that she knew they were black, because she could not see their faces, I thought.
Well, it was part of the reason, but she did testify at trial that she saw the face and the noses and knew that they were young black males. So that is an inconsistency, but I think the jury could certainly find that at night, purple gloves with baggy sweatshirts, that perhaps she mistook purple for black. I think that's a reasonable inference. So Miss Andrade, and she's well aware of her situation, well aware where she's walking, and Ramel Ahart is the only person in this case, the defendant, who's 4 inches taller than anyone. So the defense is it's James Miller and Ahmad Bright who were the shooters. They're the same height. They're both 5'9". So the only person in this case of the three that was 4 inches taller is Ramel Ahart. Jamie Andrade testified on direct examination, I do not remember them being on the phone. Or in other words, were the two men you saw on the phone? I don't remember them being on the phone. On cross-examination, I don't remember them being on the phone. It's possible. Ms. Andrade did not say, as counsel suggested, I don't remember if they were on the phone. I don't recall if they were on the phone. She said, I don't remember if they were on the phone. Excuse me, she said, I don't remember them being on the phone, was her statement. And that's at transcript 10, page 92. In the closing argument, the statement was, she has no memory of them being on their phones. Virtually identical statements, both in words, but certainly in substance. But to move past the statement of Ms. Andrade, what's critically important in this case is the Commonwealth asked the jury to draw the reasonable inferences from the admitted evidence. And the most powerful evidence in this case was the cell tower records. Vincent Moise, an employee of Sprint Nextel, was a radio frequency engineer. And he testified to the area of Central Square with 4 different cell towers. In the substance of his testimony, to a reasonable degree of scientific certainty, and he tells the jury that these cell tower records are 99% accurate. And he tells the jury, if you are on Hamilton Street, you will not hit off of cell tower 1706. If you are hitting off of cell tower 1706, you would not be on Hamilton Street. James Miller's testimony throughout the trial is corroborated by those cell towers. When James Miller told the jury that Ahmad Bright got a phone call from Sherrod Bright, and Ahmad Bright's case was recently affirmed by this court. When Ahmad Bright got a phone call from Sherrod Bright, the cell records indicate that. When James Miller said we then traveled to Boston for Ahmad Bright to pick up a firearm, the cell towers show the car in the phone calls traveling from Cambridge to Washington Street, where Ahmad Bright and Sherrod Bright lived, back into Cambridge. But the power of the evidence is that 11 phone calls between 11:45 and 11:53, James Miller's phone is hitting off of cell site 1706, which has a coverage area of a particular area in Cambridge that does not include Hamilton Street.
And the murder occurred at that point in time?
The murder occurred at 11:52 p.m. That evidence is deduced from a gentleman, Mr. Danglow, who was sitting in his house watching Saturday Night Live, heard gunshots, He said within 30 seconds he placed a 911 call. That 911 call came in right at 11:53, meaning the incident happened, if you credit Danglo's testimony, at 11:52 and 30 seconds. James Miller is still up on Pacific or the area of Pacific Street speaking with Sally Texera, and she testified, I spoke with James Miller, and she was shown the 11:53 phone call, and she said, yes, that's the phone call. So the cell towers, James Miller testified that the two defendants threw their phones in the Jeep before they left to commit this murder. What's also critically important is the cell records themselves, the incoming and outgoing phone calls. There are no incoming and outgoing phone calls to or from Ahmaud Bright or Ramel Ahart's phone records. And that was the point of the closing argument. Ramel Ahart was not on his phone. You know that from Jamie Andrade, you know that from James Miller, and you know that from the phone records.
Well, wasn't there, am I right that the evidence was that, in fact, Corey Davis was on the phone with James Miller at the time that the two shooters, whomever they were, shot?
That is correct. 30 seconds prior, Troy Davis testified that James Miller was on the phone with Corey Davis. The phone hangs up, and within 30 seconds, shots are fired. So James Miller could not have been on Brookline Street, made a right-hand turn, walked down Hamilton Street, hung up the phone at that corner where Jamie Andrade said they weren't on the phone, and then got his way down to the car, committed the murder, then made his way back to the corner of Hamilton and Brookline to throw away the murder weapon, and then place a phone call to Sally Texera at 11:53 in a normal voice, say, I need you to pick me up. The argument also belies logic. Ahmaud Bright, according to Jamie Andrade, took change out of his pocket and threw it in the bushes because he was so concerned, the inference is, with noise, with anyone hearing them, with Corey Davis hearing them. So if Ahmaud Bright is so concerned about noise, why would James Miller make a phone call and have a conversation where people could hear? That just does not make sense. And that was the basis of the Commonwealth's closing argument and why it could be believed that James Miller was not the shooter. And therefore, you could believe James Miller when he tells you Ramel Ahart was. If there are no other questions on that point, turning to the argument that counsel was precluded from asking probative questions having to do with bias, prejudice, or motive.
Or having, yes, and more particularly having to do with the possibility of being charged with a crime in connection with this.
Certainly. So my sister had stated that it would be impossible for trial counsel to have asked the perfect question in that situation. But in essence, trial counsel did ask the perfect question 40 pages prior in the transcript. Transcript 9, page 69, trial counsel said, and since that time, having been brought back to Massachusetts and told everything that you have told, the story that you have, you've never been charged with accessory before the fact of murder, have you? No. You've never been charged with accessory after the fact of murder for riding away with people you say killed Corey Davis. Is that right? Answer, no. Later on in the examination, there is a discussion about this rap CD. A lot of the witnesses in this case were allegedly aspiring musicians. And there was a rap CD that came about. And Ramel Ahart's girlfriend, Tamika Harvey, testified that this CD was made the day after the murder, and the lyrics, and the theory was the lyrics in the CD are so similar to the shooting that it must have been James Miller's confession. And trial counsel specifically asked James Miller about that. Excuse me for one moment. And he asked him, the rap, and he laid the foundation that the rap is incredibly similar, and it talks about shooting someone in a black ride and whatnot. Went through that whole scenario of how it was similar, and he says, the rap shows you had a motive to lie and fabricate what happened in this case, doesn't it? Answer, if that's what you think. Question, you do have a motive to blame others in order to save yourself from prosecution, don't you? No. So trial counsel addressed that exact issue. Later on in the examination, trial counsel asked him, "You don't want a murder charge, do you?" "No, who wants a murder charge?" "You didn't need a lawyer when you went to see Judge Bornstein because you had Forster and Fulkerson, the two detectives." "I didn't do anything wrong," was the answer. So for the better part of 2 days, in 148 pages of examination, trial counsel's sole purpose was to impeach James Miller on his motive, on his bias, on his reason to lie, with his prior convictions, with inconsistent testimony, with the fact that he lied on numerous occasions. So for that purpose, Mr. Ahart was not foreclosed of all opportunity. And of course, that's what the case law says. When there's motive, bias, prejudice, evidence, all area of inquiry cannot be foreclosed.
But your point, I take it, is not just that he wasn't foreclosed from all, but that in fact he pursued this particular specific area of bias, that is the potential for charges that never came to be.
Absolutely. That is exactly my point.
Can you tell me, as far as that CD was concerned, I understood that Mr. Miller said, well, that was done a long time before the murders.
Yes, Your Honor.
Was there any evidence of when the CD was done?
There's evidence of when it was done, and also, more importantly, there's evidence of when it was not done. When it was done, the evidence of when it was done, James Miller testified. He got out of jail, I believe he said, in December or January, and he had written these lyrics while he was in jail, and he talked about how this was a way to pass time in Billerica, that we would write lyrics and we would do something called a rap battle back and forth, and that's been popularized.
December, January of the same year?
Well, December would have been the previous year, but,
Right.
but January.
Yeah.
And then James Miller's cousin, Justin James, who was more of an aspiring rapper, he actually had something called a mixtape, which is the first step to getting a CD. And he testified that he and James Miller had talked about those lyrics, and those were lyrics that he had heard James Miller rap or rhyme or style, if you will, much prior to the incident. But what's most important in this case is the defense theory was that this CD was made after the murder. And of course, if the theory is it's a confession CD, then it would have to be made after the murder. So much so that counsel had a theory that on the 19th, the day after the murder, everyone went to this rap studio and made the CD. And that the raps, and so much so they produced a receipt. March 19th, between 7 p.m. and 9 p.m. was the studio time. But the cell tower records show that James Miller was not in Dorchester between 7 and 9 on March 19th. He was down by Boston University, and then he traveled to Cambridge, where his girlfriend, Sally Teixeira, worked, serving food at Harvard University. So by the defendant's own theory that this CD was made after the murder between 7 and 9 on March 19th, the scientific evidence, which was not refuted at trial, shows it could not have been so.
But the CD just coincidentally had reference to 6 bullets.
That is correct, and there was a lot of testimony about that, and there was a lot of discussion about that. Justin James, who again is the cousin of James Miller, who has this mixtape out there, which again is the precursor, allegedly, to making a CD, he testified, sex, violence, guns, and drugs. That's what sells in rap music, and that's what they were talking about. And James Miller was directed and cross-examined about his song. That rap song talked about .45 caliber firearms. It talked about the Oakland Raiders. It talked about selling marijuana. It talked about girls in not so flattering light. None of that had to do with the murder. So, and as James Miller testified on cross-examination, Corey Davis and a lot of other people have been shot with 9mm firearms. It doesn't mean I was rapping about Corey Davis. So, is that it?
With regard to the cell phones, are phone calls necessary to get those measurements, or is it just that the phone itself?
This particular method, which is called cell site information, which was obtained from 18 United States Code 2703D, you need phone calls or text messages to get that. There is another way to do it if you ping the phone, which requires a higher legal standard. So this was incoming and outgoing phone calls or text messages, which were able to let the police, upon appropriate court order to get the information, know where the person was at the time the phone call or text message was made. Of course, you need to put the phone in the person's hand. And in this case, there was ample evidence on James Miller's part of people he spoke to, Sally Texera, Troy Davis, things of that nature. Turning to the argument that the Commonwealth impermissibly vouched for Lieutenant Forster when it talked about his training experience. Counsel cites a case, McCoy case, which is an appeals court case. This case, and the use of Lieutenant Forster's testimony in closing argument, is drastically different than the McCoy case. In the McCoy case, that was a drug case in which the prosecutor, according to the court, made numerous errors. With regard to the vouching error, the prosecutor got up and said, these two detectives with 25 or 26 years combined experience protecting and keeping your streets safe, keeping your streets safe of drugs, came in here and told you what they knew. And you'd have to believe they were lying. So the purpose of the argument in McCoy was to show that these officers have been doing it for 26 years, they've been keeping your streets safe for 26 years. And therefore, you should just believe them. The other problem in the McCoy case was the prosecutor got up and said, defense counsel is calling these police officers liars. Defense counsel in McCoy didn't call the police officers liars. He didn't even suggest they were liars. In our case, trial counsel alleged that there must have been some secret deal between James Miller and the police. And he went so far as to ask James Miller and to argue in closing, did Lieutenant Forster wink at you when he told you there was no deal? So when he's saying you can't believe James Miller that there was a deal, that there wasn't a deal in the murder, he's saying that's a lie. He's therefore saying Lieutenant Forster, when he testified to the same thing, that was also a lie. The Commonwealth rightly replied by pointing out that Lieutenant Forster testified he'd been doing homicide work for 20 years and done over 100 homicides, and he knew, based on his training and experience, that he did not have the authority to make a deal. He wasn't authorized to make a deal. This wasn't some mistake. This wasn't something he thought he could do. This wasn't something he did because he knew he didn't have the authority. In the trial, in the closing, the jury was simply asked, you judge for yourself. Does Lieutenant Forster look like the winking type to you, was the statement. You decide whether or not you believe Lieutenant Forster when he told you he didn't make a deal and didn't have the authority to make a deal. So for those reasons, there was no error in that argument. Turning finally to the argument that there was abuse of discretion by exempting Lieutenant Forster from sequestration. Of course, as this court knows, the purpose of a sequestration order is to keep a witness from perjuring himself. The record reflects that Lieutenant Forster testified in the Ahart trial, that counsel had the transcripts. Lieutenant Forster wrote reports that Lieutenant Forster testified at grand jury. And there was no allegation by anyone, defense counsel at trial, a motion for a new trial or anything of such, that Lieutenant Forster had perjured himself. Lieutenant Forster, everything he had to say, particularly that there was no deal on the murder for James Miller, that was part of the record and well established from the beginning of the trial. So there was no risk that Lieutenant Forster would have or did perjure himself. So for those reasons, there is no error. If there are no other questions, I will rest on my brief.
Thank you, counsel.
Thank you, Your Honor.
We'll take a brief recess.